Thank you for taking the time to view what we originally envisioned as a 5-minute overview of the FERPA Act and what it means for educators in the state of Alabama. That said, when we started to delve into the multiple rules and repercussions of FERPA, we quickly realized that 5 minutes was not enough time to effectively cover the subject. So let me welcome you to our video overview of FERPA, more accurately entitled FERPA in 5-ish. As you can see on your screen, FERPA has been around for a long time, since 1974, and has always had as its primary focus the protection of student privacy. The reason that FERPA now seems to be a much greater concern is that technology now provides us with many more opportunities to share student-level data and to do so in a manner that violates rules found in FERPA. This increases the disclosure risk we now face. When we talk about disclosure risk, how do we evaluate it? Well, on the screen you see a definition that is paraphrased from the Act itself. This language is fairly straightforward, with the exception of the word reasonable, which has different connotations for different individuals. But there are some thresholds that can be objectively determined. For instance, if you release information on a subgroup in a school with less than 10 members, there is a significantly elevated risk of disclosure and, by extension, a violation of FERPA. This helps to explain why data reported from the State Department of Education, even though aggregated to the school level, does not include data for subgroups smaller than 10. So if FERPA's intent is to safeguard the privacy of students, for the purposes of this Act, how is a student defined? Well, on your screen you see that definition. And at the first bullet, the words "actually attends an educational institution" are underlined for a reason. The person has to be in attendance to be considered a student. And since January 8th of 2009, those in attendance on online institutions have also been considered a student. As you can tell from your screen, the list of personally identifiable information is rather extensive, and schools must have a parent or student's written consent prior to disclosing any portion of their personally identifiable information. The U.S. Department of Education has, however, clarified that when you're trying to gain a signature from a student or a parent, an electronic signature may substitute for a written one when you are seeking to be able to disseminate any of the information found on your screen. Though federally funded institutions must get written permission to share personally identifiable information in most instances, there are exceptions to that rule. Those exceptions are shown on your screen. There are also exceptions for emergencies, and schools may make non-consensual disclosure of personally identifiable information if it is necessary to protect the health or safety of students or others, if they are in imminent danger or in an existent emergency. There are also exceptions for school officials, but please recognize that this says access and not share. In addition, you can think of legitimate educational interest as a need to know that is essential to carrying out one's job responsibilities related to education. In the Act itself, specifically in Section 99-33, it clearly states that an educational entity may disclose personally identifiable information from an educational record only on the condition that the party to whom the information is disclosed will not disclose the information to any other party without prior consent of a parent or eligible student. It furthermore states that the information may only be used for the purpose for which the disclosure was made. In 1994, the Improving America's Schools Act amended several components of FERPA, tightening the privacy assurances for students and families. In that amendment is language specifying that a third party that inappropriately re-releases personally identifiable information from an educational record cannot have access to educational records for a period of 5 years. What is directory information? Well, it's personally identifiable information that is not generally considered harmful or an invasion of privacy if disclosed. It can never include a student's social security number. A parent or eligible student may not opt out of disclosure of directory information in order to prevent a school from requiring a student to wear a student ID badge that exhibits information that the school has properly designated as directory information. Throughout the law, you have lists of exceptions for directory information, but I do want to emphasize that directory information may never include social security numbers. At the elementary or secondary level, records that are gathered by a nurse or a health center come under the subject of FERPA, not HIPAA privacy laws. It is also important to note that nothing in FERPA precludes an educational institution from including in the educational records of a student any appropriate information concerning disciplinary action taken against that student for conduct that posed a significant risk to the safety or well-being of that student, other students, or other members of the school community. This information may also be disclosed to others who have been determined to have legitimate educational interest in the behavior of the student. The FERPA Act speaks to educational records in addition to personally identifiable information, since they can be tied to an individual. You can see a list of educational records on your screen. The last bullet states payroll records for employees who are employed as a direct result of their status as students. And these may include work-study students, assistantships, or resident assistants. Though educational records are covered by FERPA, several types of records that are a product of the educational setting are not covered in the Act. And they include, but are not limited to, some of the documents you see on the screen now. Sole possession records made by a faculty and staff for their own purpose and used as reference or memory aids are not considered educational records, nor are personal observations, alumni records, or peer-graded papers and exams prior to the grade being recorded in the instructor's gradebook. In the FERPA Act, there is reference to a requirement for annual notification. On your screen, you see that each educational agency or institution shall annually notify parents of students or eligible students currently in attendance of their rights under FERPA. An agency or institution may provide this notice by any means that are reasonably likely to inform the parents or eligible students of their rights. And a key component is that an agency or institution shall effectively notify parents who have a primary or home language other than English. On your screen now, you see the key components of the inspection, review, and corrections aspect of the Act. And full rights under this Act must be given to either parent unless the agency or institution has been provided with evidence that there is a court order, state statute, or legally binding document relating to such matters as divorce, separation, or custody that specifically revokes these rights. FERPA Act enforcement is carried out by the Family Policy Compliance Office and the Office of Administrative Law Judges. Non-compliance can result in the withholding of further federal payments under any applicable programs, issuance of a complaint to compel compliance through a cease and desist order, or terminating the eligibility to receive federal funding under any applicable program. For any additional information regarding FERPA or to access other videos, please contact the Privacy Technical Assistance Center at the website on the screen. Thank you.